Did you know that the UK Parliament could still legislate for the states even after the enactment of the Australian Constitution? And did you know that this has just changed a few decades ago? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will see what happened to the legislative powers of the states by doing an overview of four very important acts: the Colonial Laws Validity Act of 1865, the Commonwealth of Australia Constitution of 1901, the Statute of Westminster of 1931, and the Australia Acts of 1986. Before the Commonwealth of Australia even existed, there were 6 colonies. During the colonial times, as we have seen before in this channel, the legal structure was quite messy. There was a mix of English laws and colonial laws operating at the same time. The governor had quite extravagant powers, and the principle of responsible government was still maturing. In this context, in 1865, the UK Parliament passed the Colonial Laws Validity Act. We have a video about this act, so I'll summarize it to say that the Colonial Laws Validity Act gave each colony the power to amend the common law and amend or repeal statutes that were not really applicable to the colony. The act still continued to allow the UK Parliament to legislate for the colonies. However, now the local legislatures could enact new laws if they were not repugnant to English laws, and could amend or even repeal the English laws that did not operate by paramount force. If you got a bit lost here, I encourage you to check our previous video about the Colonial Laws Validity Act. You can see the link to it in the description of this video below, or by clicking in the little cards that appear here in the top right corner of your screen. Alright, fast forward a few decades and we have the constitutional conventions happening from 1891 to 1899. Representatives of every colony got together to deliberate on the drafts and the propositions of a federal constitution. When the constitution was ready, all colonies had to approve the text by referendum. So here we see an interesting feature of the Australian Constitution actually. The people of the colonies, soon to be the states, decided whether or not they would join the federation. They decided whether or not they would agree to the text of the federal constitution that was being proposed. And so it was upon request of the citizens of the colonies that the constitution was sent to the UK for approval by the UK Parliament. And this is why Western Australia is not in the preamble, right? Because by the time the Committee of Representatives set sail to England, the people of Western Australia hadn't yet voted in the referendum to accept to join the Federation. The Constitution was approved by the British Parliament on 5 July 1900, with Queen Victoria assenting to it 4 days later. And the Constitution, as you know, came into force in Australia in January 1, 1901. In our last video, we saw how the Constitution reserved the powers of the states. Sections 106, 107 and 108 say that the Constitution's powers and laws of the state are to continue even after the Federation, subject of course to the new Constitution and the transfer of powers to the newly created Commonwealth of Australia. Now, think with me. The Colonial Laws Validity Act said that the colonies could legislate to amend or repeal certain laws of the UK Parliament. But other laws had been integrated into the state's legal system. These laws would continue. And more, the Colonial Laws Validity Act also said that the UK Parliament would continue to legislate for the colonies, now states. And the new constitution of the Commonwealth does nothing to change that. So yeah, the Australian Constitution had been enacted, but the UK Parliament could continue to legislate for the states if the laws were to operate by paramount force. In fact, in my first video in this channel, I explained how the Australian Constitution is part of an act of the British Parliament. So if you think about it, the UK Parliament still had the power to legislate for Australia and its states even after the Constitution. This situation would change only a few decades later. In 1931, the British Parliament enacted the Statute of Westminster, literally saying that the Colonial Laws Validity Act would no longer apply to the legislative powers of the federal parliament. The act also said that the British Parliament would not legislate for Australia unless they were requested to do so by the federal parliament, which had never happened before. In 1942, the federal parliament enacted the Statute of Westminster Adoption Act, which incorporated the Statute of Westminster as part of our domestic law here in Australia. Great! We have the Constitution that delimits the powers of the Commonwealth and the Statute of Westminster that says that the UK Parliament will only legislate for Australia if the federal Parliament had requested and consented to it. But what about the states? The Statute of Westminster applied to the federal level only. And as we said before, the Constitution does not have anything that repealed the Colonial Laws Validity Act. All in all, that is to say that up to this point in time, there's still the possibility of the UK Parliament legislating directly to the states, even if it cannot legislate to the Commonwealth anymore. The resolution of this conundrum only came in 1986. That's right. 1986, and that happened with the enactment of the Australia Acts. Okay, do you see that I'm referring to these in the plural form, acts? Let me tell you why. Since the Statute of Westminster did not apply to the states, the British Parliament enacted the Australia Act 1986, removing its own power to make any law whatsoever for Australia, including the states. But the problem was, the British Parliament had no authority to legislate for Australia anymore. That's to say, the Act of the UK Parliament would have not been applied at the federal level and incorporated to domestic law in Australia. So, to make it all work, here's what they did. Following Section 5138 of the Australian Constitution, the parliaments of all states requested the federal parliament to enact an act to give effect to the Australia Act as enacted by the UK Parliament. There's a mechanism in Section 51 that allows the states' parliaments to give authority to the federal parliament to legislate on their behalf. And this is what they did. So, with that, the UK law could be applied to Australia if the federal parliament requested the law to be enacted and then consented to that law. Ultimately then, the UK Parliament enacted the Australia Act. The Commonwealth consented to the enactment of the Australia Act, and then the Commonwealth Parliament enacted its own Australia Act, which is an exact copy of the UK Act. That's why we have the Australia Acts. Section 1 of the Australia Act says that no act of the Parliament of the United Kingdom passed after the commencement of this Act shall extend or be deemed to extend to the Commonwealth, to a state or to a territory as part of the law of the Commonwealth, of the state or of the territory. Section 3 terminates all powers and influence of the UK Parliament over the parliaments of the states. In fact, the section expressly repeals the Colonial Laws Validity Act, removing the authority of British Parliament to enact legislation to the states. Section 5 also safeguards the Constitution and the Statute of Westminster, maintaining their validity and operation even after the enactment of the Australia Act. And one more thing to highlight is that the right to appeal from State Supreme Court decision to the Privy Council was also removed by the Australia Act. That right had also already been repealed from decisions of the High Court back in 1975. So now we've come to the full circle. The English laws that operated during the colonies and the authority of the UK Parliament that had been invoked since the colonial times with the Constitution and with the Australia Acts have been removed and extinguished. Both the states and the Commonwealth can legislate without any interference from the UK Parliament. I hope you enjoyed this brief overview of the relevance and development of these important acts of Parliament from the Colonial Laws Validity Act to the Australia Acts. And of course, I hope to see you again very soon. Until then, ciao.